Because January 6th was an unprecedented attack on the seat of our democracy, we understand that there is broad public interest in our investigation. We understand that there are questions about how long the investigation will take and about what exactly we are doing. Our answer is, and will continue to be, the same answer we would give with respect to any ongoing investigation. As long as it takes, and whatever it takes, for justice to be done consistent with the facts and the law. I understand that this may not be the answer some are looking for, but we will and we must speak through our work. Anything else jeopardizes the viability of our investigations and the civil liberties of our citizens. Everyone in this room and on these screens is familiar with the way we conduct investigations, and particularly complex investigations. We build investigations by laying a foundation. We resolve more straightforward cases first because they provide the evidentiary foundation for more complex cases. Investigating the more overt crimes generates linkages to less overt ones. Overt actors and the evidence they provide can lead us to others who may also have been involved. And that evidence can serve as a foundation for further investigative leads and techniques. In circumstances like those of January 6th, a full accounting does not suddenly materialize. To ensure that all those criminally responsible are held accountable, we must collect the evidence. We follow the physical evidence. We follow the digital evidence. We follow the money. But most important, we follow the facts. Not an agenda or an assumption. The facts tell us where to go next. Over 40 years ago, in the wake of the Watergate scandal, the Justice Department concluded that the best way to ensure the department's independence, integrity, and fair application of our laws, and therefore the best way to ensure the health of our democracy, is to have a set of norms to govern our work. The central norm is that in our criminal investigations, there cannot be different rules depending on one's political party or affiliation. There cannot be different rules for friends and foes, and there cannot be different rules for the powerful and the powerless. There is only one rule. We follow the facts and enforce the law in a way that respects the Constitution and protects civil liberties. We conduct every investigation guided by the same norms, and we adhere to those norms even when, and especially when, the circumstances we face are not normal. Adhering to the department's long-standing norms is essential to our work in defending our democracy, particularly at a time when we are confronting a rise in violence and unlawful threats of violence in our shared public spaces and directed at those who serve the public. We have all seen that Americans who serve and interact with the public at every level, many of whom make our democracy work every day, have been unlawfully targeted with threats of violence and actual violence. Across the country, election officials and election workers, airline flight crews, school personnel, journalists, local elected officials, U.S. senators and representatives, and judges, prosecutors, and police officers have been threatened and or attacked. These are our fellow citizens who administer our elections, ensure our safe travel, teach our children, report the news, represent their constituents, and keep our communities safe. Some have been told that their offices would be bombed. Some have been told that they would be murdered, and precisely how, that they would be hanged, that they would be beheaded. Police officers who put their lives on the line every day to serve our communities have been targeted with extraordinary levels of violence. Flight crews have been assaulted, journalists have been targeted, school personnel and their families have been threatened. A member of Congress was threatened in a gruesome voicemail that asked if she had ever seen what a .50 caliber shell does to a human head. Another member of Congress, an Iraq War veteran and Purple Heart recipient, received threats that left her terrified for her family. And in 2020, a federal judge in New Jersey was targeted by someone who had appeared before her in court. That person compiled information about where the judge and her family lived and went to church. That person found the judge's home, shot and killed her son, and injured her husband. These acts and threats of violence are not associated with any one set of partisan or ideological views, but they are permeating so many parts of our national life that they risk becoming normalized and routine if we do not stop them. That is dangerous for people's safety, and it is deeply dangerous for our democracy. In a democracy, people vote, argue, and debate, often vociferously, in order to achieve the policy outcomes they desire. But in a democracy, people must not employ violence or unlawful threats of violence to affect that outcome. Citizens must not be intimidated from exercising their constitutional rights to free expression and association by such unlawful conduct. The Justice Department will continue to investigate violence and illegal threats of violence, disrupt that violence before it occurs, and hold perpetrators accountable. We have marshaled the resources of the department to address the rising violence and criminal threats of violence against election workers, against flight crews, against school personnel, against journalists, against members of Congress, and against federal agents, prosecutors, and judges. In 2021, the department charged more defendants in criminal threat cases than in any year in at least the last 5. As we do this work, we are guided by our commitment to protect civil liberties, including the First Amendment rights of all citizens. The department has been clear that expressing a political belief or ideology, no matter how vociferously, is not a crime. We do not investigate or prosecute people because of their views. Peacefully expressing a view or ideology, no matter how extreme, is protected by the First Amendment. But illegally threatening to harm or kill another person is not. There is no First Amendment right to unlawfully threaten to harm or kill someone. As Justice Scalia noted in RAV versus City of St. Paul, true threats of violence are outside the First Amendment because laws that punish such threats, quote, protect individuals from the fear of violence, from the disruption that fear engenders, and from the possibility that the threatened violence will occur. The latter point hits particularly close to home for those of us who have investigated tragedies ranging from the Oklahoma City bombing to the January 6th attack on the Capitol. The time to address threats is when they are made, not after the tragedy has struck.